Welcome to The Landlord Advocate.
Hey everybody, welcome into an all-new episode of The Landlord Advocate with Matthew Paletz, the CEO of Paletz Law and Paletz Law attorney. I am your host, Mike Leon. Joining us on this episode is an associate over at the firm, Breanna Kingsley, and they're going to be breaking down a very interesting topic here. But first, let me tell you a little bit about Matthew and the team, because they've spent decades helping landlords navigate these complex issues out there, like lease enforcement, tenant default, and bankruptcy filings. And in today's episode, we're going to talk about what happens when a tenant files for bankruptcy and how landlords can protect their interests without accidentally violating the law. It's good to see you guys. Matt, I'm going to start with you on this question here. So let's explain, how often do tenants usually file for bankruptcy?
You know, and it's great to see you too, Mike. Thanks for having us today. It really depends. Unfortunately, the economy has been taking a little bit of a nosedive lately with inflationary pressures hitting everybody, especially at the kitchen table. So we have seen a definite surge in bankruptcy filings. Not sure exactly, haven't really consulted my crystal ball to see what that's going to take place in 2026. But right now, yeah, we've definitely seen some individuals who are struggling financially, and unfortunately, it's impacted their ability to meet their rental requirements. And so they have filed bankruptcy, unfortunately.
Yeah. And Breanna, I know this is an area of expertise for you. So how long does the bankruptcy process take for a landlord?
Well, it really just depends on whether or not it's a Chapter 7 or a Chapter 13. A Chapter 7 bankruptcy lasts much shorter than a Chapter 13. A Chapter 7 is if the tenant has just decided, you know what, I'm done. I need to move on. I want to discharge some of my debts. A Chapter 13 is much longer, and it helps for reorganization of debts.
Yeah, and Mike, with that, a lot of people talk about a lot of different types of bankruptcies when they refer to them as chapters. That just means in the bankruptcy code. A lot of people hear the word Chapter 11 a lot. That typically has to do with businesses. And what we deal with primarily is when individuals, typically renters, and they have that choices of what Breanna was talking about due to the case of how financially insolvent and what the level of that is. And that is why they either file a Chapter 7 or a Chapter 13.
Yeah. Matt, let me stay with you for a second, piggyback on the bankruptcy part of this. Are they legitimate, or are they sometimes used by tenants as a delay tactic?
That's a great question, Mike. I would say that most are legitimate, right? People, unfortunately, have either maybe lived beyond their means, or they've had some sort of hardship, a medical issue, or something like that. And so, unfortunately, they didn't have enough to save for a rainy day, and it drove them into having to file bankruptcy. But just like with anything else, there is some abuse in the system. And we have seen incidents where tenants have filed repeatedly. There are some protections in the court that finally put a stop to that, but it does take time. And that time means a lot of money and negative cash flow to a property owner's unit. And that can create a strain. And what people don't understand is when a tenant files bankruptcy, yes, of course, we have to be sympathetic to what they're going through. But also that has a negative impact on the financial health of the building that they're occupying. And I represent quite a few mom and pop landlords. And believe me, if they're relying on that part of the tenant's rent to pay towards their mortgage obligation, that's very difficult. The landlord doesn't get to say to the mortgage company, well, my tenant filed bankruptcy, so you're going to have to wait. Not going to happen. So you definitely need to have expert legal counsel to help you navigate through these waters, because it can have an impact and it can happen pretty quickly.
So, Breanna, let me piggyback on something Matt said there, which is what is the first thing that landlords need to understand as soon as they've been notified that that tenant has filed for bankruptcy?
So as soon as they've been notified that the tenant has filed, they should be aware that there's a stay in place. Essentially, the stay will stop any collection efforts or any sort of action to remove them from the property, anything essentially regarding their tenancy. The bottom line is they should reach out to their attorney as soon as they're notified. So the sooner they get us involved, the sooner we can take action.
And Matt, let me ask you, what is exactly an automatic stay? What are the actions that the landlords are legally prohibited from taking effect once this kicks in?
Yeah, I like the word action. I like that Breanna said we take action. That's what Paletz Law does. We take action. And look, an automatic stay is just a fancy word for a pause. What happens is when someone has, and the tenant now is called a debtor, right? They're a debtor. The landlord is called a creditor. And so what happens is they're asking the court for protection from their creditors so that they can basically take a pause, assess what their financial picture is, and see if there's a resolution to see if they can say, look, I got into some financial trouble. How can we resolve this? Either how can I continue a tenancy, or otherwise, how can I repay back the monies that I owe you in certain situations? But the stay is in place, and it's very important to know, especially from a creditor, in our case, our landlord clients, that once that stay is in place, you have to hold off on any sort of eviction proceedings or collection proceedings until you've navigated through that. A lot of people don't understand that when you're dealing with those kind of cases like evictions or collections, and I'm not trying to bore the audience here, I know you like this subject a lot, right?
It's very interesting to me. I enjoy it. There's so many things you can do with bankruptcy.
I am glad that you like it. But what happens is that stay is in place, and so there are protections for the tenant debtor. And if you violate that stay, if you continue to act in let's say the state court that you were in, and understanding that bankruptcy is a federal court, you have to pause what you're doing anywhere else. You got to deal with it in federal court, and then you got to figure out, okay, what's the play going forward? And if you violate that, then you can be subject to sanctions and penalties. So it's very, very important that you recognize that that's in place and get your lawyer involved and make sure that they know what's going on, because if they don't, there can be potential consequences that you're going to have to pay some fines and costs on it.
Yeah, it's not boring me because it's important information for people to understand. So, Bree, let me ask you a Captain Obvious question. Maybe it's not. Is the landlord pretty much kissing goodbye any past rent that's been owed after this bankruptcy is filed?
No, I wouldn't say that. Not necessarily. Again, it depends on whether or not it's a Chapter 7, it's a Chapter 13. As Matt indicated earlier, Chapter 11s are a little different because they deal with businesses. If you're in a Chapter 7, essentially, yeah, you're going to say goodbye to that rent. If you're in a Chapter 13, most of our clients are called, again, a boring term, unsecured creditors. So you may get pennies to the dollar on what you're owed, but you still might be able to get paid over the lifetime of the Chapter 13.
That may have been a boring term. Okay, I'll agree with you on that one. Matt, let me ask you. Let's go back to the landlords and the tenant relationship here. Are there specific lease terms that can help landlords out there better handle tenant bankruptcies in the future?
Yeah, my clients ask me that all the time. They're like, well, is there something we can put in the lease says that they cannot file bankruptcy? Or like, I don't know if you're a person who likes the show The Office, where Michael Scott says, I declare bankruptcy. You can't just declare bankruptcy, and you can't just say, well, I prevent you from declaring bankruptcy. It doesn't work that way. If a court has adjudicated that the bankruptcy is valid and can go forward, there's really not much you can put in as a clause in a lease. The really focus should be is making sure that your field personnel or anyone that's interacting with the tenant or gets a notice immediately gets legal involved. And that way, we can take steps that are legal within the law to make sure that we're doing everything we can to protect their interests as the property owner, and to make sure that the tenant isn't abusing the system, and try to make sure that the time frame doesn't get artificially elongated. Because let's face it, time is literally money in the property management and landlord business, and anything that's interfering with that can have, as I previously said, some devastating financial impact on the property at large. So the most important thing, as I said, is you just got to let your field personnel, when you get a bankruptcy notice, you just shouldn't disregard it. You really need to let your legal counsel handle it. And I would say, yeah, when that happens, if you ignore it at your peril, that does not get boring. That gets exciting in a hurry.
That's definitely true.
Yeah, you can't just yell bankruptcy. Well, I declared it. Well, that's not how it works, Michael. So,
it's not how it works.
It's not how it works. Breanna, let me ask you guys, how many of these cases would you say you guys have handled, and what sets you guys apart when you're helping landlords in these situations?
Well, I definitely would say I haven't handled as many as Matt.
Well, what are you trying to say?
And you have been practicing a very long time, longer than me.
Yeah, I think you commented the other day that I've been practicing law almost as long as she's been alive. So
almost, not almost there, but close enough. But I definitely have handled a lot of bankruptcy cases over my nearly 5 years almost of being an attorney. So again, not as many as Matt, but we do have a whole department that deals with our bankruptcy matters. I'm a part of that, and a few other attorneys get involved. Matt sometimes gets involved when things get a little not so boring.
Yeah, sometimes it's just, we have a really good team here. Breanna does a great job. Certainly, though, it's collaborative. That's another thing at Paletz Law that we offer to our associates who come on board. We spend a lot of time on training. We're very collaborative in our approach. There's times where, someone has to be in the deep end of the pool and see if they can swim or not. But I'm just not a big proponent of teaching in that manner. I'd rather, why reinvent the wheel? So the bankruptcy department is a definite example of sometimes it just takes a few hands involved because the bankruptcy code can get, very complicated sometimes.
Yeah.
And so we take that kind of approach, and I'm really proud of the work that we do here on behalf of our clients. We are very mindful and we are very sympathetic to individuals going through financial uncertainty and difficulty. It's not a good time for anyone. And we are appreciative of this. My clients are appreciative of this. My clients don't want to see people, unfortunately have to lose their housing. But on the same token, my clients, as I said, they have financial obligations that they have to meet too. And so it's not just isolated when a tenant files bankruptcy. It does have impact at large. And for us, it's just trying to find that balance and figure out the best way to see if the lease can still be preserved, or otherwise try to figure out a dignified way for the tenant to have to vacate.
So, guys, as we wrap on this episode, Matt, I'll turn to you, and Breanna, you can chime in as well. What's one piece of advice for someone that's listening to this right now? Maybe they've gotten the notice that you guys mentioned before about their tenant has filed for bankruptcy. What's the first thing that they should do?
First thing they should do is get their lawyer involved. Don't disregard that notice at your peril. That's the best advice I can give any landlord who's operating. As soon as they find out that a tenant's filed bankruptcy, they need to get their lawyer involved so that they can make sure, as we talked about, they're not in violation of the stay, and also then figure out what's the best game plan to get that deal resurrected. Basically, that's the best advice I can give. What about you? Same thing?
I couldn't agree more.
There you go.
As soon as you get your attorney involved, the sooner we can take action and figure things out.
See, executive material right there.
That's it. Get your attorney involved. Thank you guys for the time and insights on all of this. I truly appreciate it.
Thanks, Mike. Appreciate your time.
Thanks for having us.
And thank you to everyone out there for listening to this installment of The Landlord Advocate. If you want to learn more about how Paletz Law helps landlords protect their rights, not only in the state of Michigan, but also on the border of Ohio right there, visit paletzlaw.com. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.